have all been affected directly by the Fair Labor Standards Act, either by being paid minimum wage or by being paid overtime pay. And in this slideshow, I'm going to tell you some history of the Fair Labor Standards Act and also explain what it is. In 1923, with the case of Adkins versus the Children's Hospital of the District of Columbia, the Supreme Court threw out a law that Washington, D.C. had that set a minimum wage for women. Then, in 1936, the Supreme Court did it again. This time it was the case of Moorhead versus Tapaldo. In this case, the court sided with Joseph Tapaldo when he was forcing his female employees to give him back the difference between what he wanted to pay them, which was $10 a week, and what the New York State minimum wage was, which was $14.88 a week. So on paper, it looked like he was paying them correctly, but he wasn't because they had to give him back the money. With both of these cases, the Supreme Court said that the minimum wage laws were unconstitutional because they interfered with the freedom to contract, which is included in the Due Process Clause of the Fifth Amendment. These unpopular decisions made it even more interesting when the Supreme Court took a left turn, and in West Coast Hotel Company versus Parrish, they decided in favor of a hotel maid that sued her employer for not paying her the Washington state minimum wage. This decision paved the way for President Roosevelt to sign into law the Fair Labor Standards Act of 1938. So, what is the Fair Labor Standards Act? This law has many details and caveats, but it mainly covers these three issues. First of all, it establishes a minimum wage that employees that are covered by this law can be paid. Currently, the federal minimum wage is $7.25 an hour. This law also requires that employees be paid overtime pay whenever they work over 40 hours a week. The work week that these 40 hours are based on does not have to be a calendar week, it doesn't have to be Sunday through Saturday, but it must be 7 consecutive days, which is 168 consecutive hours. And it must be a set 7 days. An employer can't say that it is Sunday through Saturday this week, but then because there's going to be a bulk of work, they're going to change up the days next week, and now next week the work week is going to be Monday through Sunday. They can't do that. It has to be a set amount of days. And when an employee works more than 40 hours in that set work week, all of that excess time is going to be paid at the rate of 1.5 times the normal hourly rate. So if you work 42 hours and your wage is $10 per hour, the first 40 hours are going to be paid at $10 per hour, and the next 2 hours will be paid at $15 an hour. The Fair Labor Standards Act also protects against child labor. It sets a maximum number of hours that minors can work in a week and per day, depending on whether or not school is in session. You might be thinking, wait a minute, Amy. I thought the minimum wage was $8.50 an hour. And you're right. The Michigan minimum wage is $8.50 an hour. States and cities are able to set their own minimum wages, and in Michigan, that is done through the Workforce Opportunity Wage Act. This law replaced the Michigan minimum wage law in 2014. When an employee falls under both this law and the federal law, they'll be paid at the higher rate. And the state law also requires that overtime pay is also at 1.5 times the normal hourly rate, just like the federal law does. The state minimum wage will go up again in January of 2017 and the next January as well. After that, the state minimum wage will be adjusted by the state treasurer once a year. By adjusting this pay once a year, this should hopefully avoid the rate being left alone for too long, which then results in the rate being too low. The Fair Labor Standards Act is enforced by the Wage and Hour Division of the Department of Labor. The Department of Labor has investigators all over the country that will investigate claims. These offenses are a serious matter, and while a first offense can bring a fine, a second offense can bring prison time. This is especially true with child labor violations that can bring punishments based on each employee that has been wronged. So, who is exempt? There are a few different ways to know if an employee is exempt from the Fair Labor Standards Act. One way is through the duties test. This test looks at what the employee is actually doing as their job. First is if the employee's role is executive in nature. This means that the employee is managing other employees and has the power to hire or fire employees. Another group of employees that would be exempt are administrative employees. This doesn't mean administrative assistants. To be an administrative employee for the purposes of this duties test, the employee would have 20% or more ownership of the company, or as a primary duty be making decisions that require discretion and independent judgment. Lastly, is the employee a professional? This means that the primary work requires advanced knowledge or requires originality or creativity. But wait, there's more. There's another test to determine if an employee is considered exempt, and that is the salary basis test. This test did require that the employee be paid a salary of at least $455 a week, which is $23,660 a year, which is pretty low considering that these employees could be required to work a high number of hours for no extra pay. To correct that, as of December 1st of this year, that has been doubled to $913 a week and $47,476 a year. Employers that have exempt employees making somewhere in between those two numbers now need to decide whether they are going to bump up the employee's pay to an amount above this new threshold of $913 a week, or start tracking the employee's hours and pay them overtime for hours worked in excess of the 40 hours per week. So, how about some recent cases that we can learn from? In 2012, the law firm of Barron and Budd represented a group of mechanics that were classified as independent contractors by their employer in order to not be paid overtime premiums. The mechanics worked 50 to 60 hours a week, and the judge in this case decided that they were in fact employees, and because of this, they were owed their unpaid overtime pay. Another case that was represented by the same law firm involved workers at several Jack in the Box restaurants. These employees were not paid their overtime premiums. What the franchise owners were doing was paying the employees their first 40 hours on their paychecks at their straight hourly rate. Then, any hours that they worked in addition to their 40 hours were paid to fictitious employees, again at the straight hourly rate. The employers would then cash those checks and give the money to the real employees. This was done in order to avoid paying the overtime premium. So, how can you ensure compliance? First, make sure your employees know that you do not want them to work over 40 hours a week. If that is your policy, it needs to be known. Second, don't ignore employees that are coming in before their scheduled work time, getting work done over lunch, or staying late to finish things up. If you see this happening, that isn't going to bode well when you try to defend yourself against the employee's claim for unpaid overtime later on. Lastly, you need to keep accurate records. Fair Labor Standards Act claims can go back 3 years. If, as an employer, you are lacking good records, the courts will most likely side with the employee's records.